The state's suing 13 companies for their role in failing to identify and address issues with the bridge. At what point for you did it become clear that a lawsuit was going to be filed?
Well, if you remember, the governor sometime earlier this year decided that he was going to hire counsel to bring a lawsuit. I mean, it's a long and involved story, but at the end of the day, it became clear to the governor's legal counsel that the only way to do that lawsuit and be assured that it wasn't going to be dismissed on constitutional grounds was to ensure that we were leading the lawsuit. So it came to us late in the day, but at the end of the day, we felt like it was the right thing to do. And so in conjunction with the governor's counsel, we brought that lawsuit last September.
And where does it stand now?
Well, we've filed our complaint, and what happens after you file a complaint is defendants have a number of choices. They can either answer the complaint, and then the case moves to discovery, and that's what some of the defendants did. But you can also move to dismiss the complaint on grounds that the state has no basis for bringing the case in the first place. It's often an uphill climb to do that. You have to assume that all of the facts alleged in the complaint are true. And so it puts the defendants in a relatively difficult legal position to do that, but that's what some have done. And so those motions will be heard in January, we expect. The briefing, which means the legal memorandums, are being prepared right now on both sides.
Okay, so the next step is that January hearing.
Yes, and discovery is also open. So that's an exchange of information between the state and the defendants. We provide the information that they request, and vice versa, and ultimately that leads to a place where more motion practice down the road, and eventually a trial. I think the biggest takeaway, particularly for non-lawyers, is that this litigation is going to take time, years, not months, and it's completely separate from the reconstruction of the new bridge or construction of the new bridge, and we don't have any involvement in that at all.
Mm-hmm. Do you anticipate this actually going all the way to trial, or would you prefer for it to be settled in advance?
Well, I don't really have a preference in terms of how the case concludes, except that I wanted to conclude in a way that benefits the people of the state of Rhode Island and is warranted based on the facts as we allege them. We always prepare, and when I say we, I'm talking about any legal organization that I lead. So what I mean is that whether it was when I was U.S. Attorney or now as Attorney General, and when I practiced as a prosecutor and before that, at least I always prepare as if a case is going to go to trial. When you bring a complaint, you have to be ready to try that case. And we are ready to try this one. Whether or not a case will settle along the way, I can't tell you. There are some high stakes cases, public corruption cases, for example, that are almost always trials. This is a very high stakes case for both sides. And so I anticipate it being a trial. Doesn't mean it won't settle. But I think this case is going to play out again over years and not months, for sure.
Back in March, the governor had said there'll be a day of reckoning when it comes to this Washington Bridge failure. Do you see the lawsuit as a means to that day of reckoning, or is it just about the financial damages here?
Yeah, look, I mean, I can't get inside the governor's head and really understand what he meant by that. All I know is this, that we feel that there's culpability, at least some culpability, on the part of the companies that we sued. And that the state, the people of the state, deserve a remedy for that conduct. There are lots of ways, the bridge failure and how the days following the bridge failure have been handled could be a day of reckoning for someone or some entities. But all I care about is holding those companies accountable that we sued for what we believe they failed to do on behalf of the people of the state of Rhode Island when they were contracted to do it.
How did you come up with these 13 companies and determine that these were the ones, not others, who have worked on the bridge?
Well, look, we went back, and DOT went back, and counsel for the governor, and later counsel for the governor, in conjunction with my office, and looked at the history of the bridge and who did work on the bridge that, as we allege in the complaint, should have known that continued investment in this bridge was a losing proposition for the people of the state, and didn't inform the state of that fact. Look, in any instance, we all hire experts. Okay, even though it's our home, we hire experts to help us fix the home. The analogy works here too. The state owns the bridge, but we didn't build it in the first place, and we're not the ones who have maintained it since in any kind of significant way. We hired experts to tell us what we should do and to tell us what we thought the life of that bridge could and should be. We allege in our complaint that the companies that were charged with that responsibility did not discharge it in a way that they should have, and in the end, hurt the people of the state of Rhode Island. That's why we brought the suit. That's what we allege. And I hope that there will be a remedy for the people of the state of Rhode Island.
The inspections are a big part of this lawsuit, that they weren't done properly, the complaint alleges. Now, when it comes to the inspections, DOT in their inspection manual, it says they're supposed to be thoroughly reviewing all of these inspections that are under a poor bridge rating when they get them back. If the DOT were to take some responsibility and say, yes, we should have done things differently, would that hurt the case?
Well, look, I think I'm always reluctant to speculate, but I don't think you have to be, a legal scholar to understand that where the finger pointing will come from. Obviously, the state is pointing the finger at these companies. The companies will in turn point their finger at DOT. And ultimately, if the case goes to trial, that'll be for a jury to decide culpability on the part of the state too, if there is any, and if there's culpability on the part of these companies, if there is any. Ultimately, a jury will decide that question, guided by a judge. From where I sit, again, when you hire an expert to do something, you hire them for their expertise. Sure, state owned the bridge, but these companies were charged with guiding the state as to what to do next. And we allege they failed in that responsibility.
Is it possible there's some shared responsibility here?
Oh, sure. I mean, that's always the case in a negligence case, which is really what this case comes down to, regardless of the precise legal theory. At the end of the day, the jury will decide that question. But what we allege and what I believe is that these companies had a responsibility to guide the state with respect to the reinvestment in it and its expected and its life expectancy, and they failed to do that in the way they should have and in the way they contracted to do it. I mean, that's what we allege. We have to prove it, and that's what we'll do when we get to trial.
As we talk to people about the bridge, transparency is a big frustration a lot of just the average driver has. When we spoke with DOT director, a lot of questions when it comes to how inspections are going to be handled in the future and the safety of the eastbound bridge, they're all pointed back to, we can't answer that because of the ongoing lawsuit. Obviously, you don't want to jeopardize the lawsuit at all. How do you kind of navigate those two elements of wanting to be transparent, but also wanting to get as much money as possible?
Yeah, look, I think that, I can't speak for the director. I mean, we haven't given them any directives not to share information. To my knowledge, they haven't come to us and said, can we share this or not share that? I believe, and I've always believed as Attorney General, that transparency is paramount. I mean, we are posting every single document that we can on our website related to this litigation. I don't know exactly what has been asked for, and I don't know what the director is thinking when it comes to not providing information about what might happen going forward. But that's not really my responsibility. My responsibility is handling the litigation. I know that sometimes that it's easy to say, the lawyers won't let us talk about this. But my message to DOT is, share what you can, and if you're concerned about something, come to us for guidance. To my knowledge, they haven't done that. We have been cooperating with them, obviously, to get information that we need for purposes of handling the lawsuit. But, basic information that can be shared with the public, I believe, should be.
When it comes to the legal team, Max Wistow, that the governor had hired has dropped out of the case. Does that hurt the case at all? How does that impact things?
Yeah, it doesn't. I think Max Wistow is a terrific lawyer. And, for reasons of privilege, neither he nor I can really talk about, his reasoning behind, why he wanted to leave the legal team. But I've known Max for a long time, and he's done great work on behalf of the state. That said, John Savage and his firm are terrific, and the firm that we hired will do an amazing job. I mean, they have the resources to be able to build out the litigation team, which is necessary in a case of this magnitude. So it doesn't hurt the case. The case is in good hands. This office has to lead the case, no matter who the other lawyers are. and our lawyers that we've assigned to it, Sarah Rice and Steve Provazza. You won't find better lawyers anywhere.
As part of this case, the demolition work had been paused for a couple weeks earlier this fall so that evidence could be preserved. Sure. Aetna Bridge Company is the company doing that demolition work. They're also bidding to potentially rebuild the bridge, but they're one of the companies that you're suing. Is that a conflict of interest?
No, I don't see it that way. I mean, the bottom line is litigation is what the litigation is. We need information, and we have the legal tools to get it. You know, I think at the time, look, I understand why every pause in the process raises concern, right? Because people want to get this bridge done as quickly as possible. We all have to deal with it either intermittently or, you know, for people who live or work in the East Bay, it's an everyday thing, like it is for my brother who lives in Warren and is general counsel at Providence College. He's in the traffic every day, and he shares it with me when we talk about it on the phone, and I've experienced myself. But the bottom line is that pause in the demolition, if you think about how long, frankly, it's going to take for the state apparently to get this bridge done, is a really small amount of time. You know, I think the timeline now is, you know, we're looking at well into next year before we really have a plan in place to get the bridge up and going. So that pause in demolition for us to do what we needed to do for the legal case really is not going to impact the timeline at all.
And when it comes to having a company working on the bridge with that evidence that is the actual bridge itself and also being subject to this lawsuit, is that a conflict?
No, I mean, look, we know what we need to preserve. Aetna Bridge is a responsible company, notwithstanding that we sued them. It's not like they engage in behavior that, you know, causes concern beyond, you know, the kinds of things that we sued them over. So I'm not concerned about them destroying evidence. I mean, that is not going to happen. I don't have any concerns about that. If we did, then we would have the tools in place to address it, but I'm not concerned about that.
Looking back now, a year after the bridge closed, you didn't get involved in the litigation for several more months, but is there anything you regret? Is there anything you wish you would have done differently?
Well, no. I mean, you know, the bottom line is that, you know, the governor decided that legal action was going to be one of his first responses. It's up to him to, I guess, to answer whether, you know, that's where a priority should have been placed. But the bottom line is, if the state is going to bring an action, it has to be brought, in my view, it has to be brought by us. But on the other hand, you know, I can't force myself into a case that the governor wants to bring. In other words, he controls DOT, not me. You can't bring a case like this without the cooperation of the relevant agency. They have the information you need to bring the case. So ultimately, you know, I think what the governor's legal team original thinking was, we're going to try to do it without the AG. And my answer to that is, then and now is, well, you can try to do it, but you run the risk of the legal consequences of doing it without us. When they came to us, we had a discussion about that. And my view was, look, you want to bring it on your own, you know, you're welcome to do that. You know, just speaking generally, I don't think you can, but if you want to try that, well then, you know, God bless. I mean, I think ultimately they realized that it was smarter to have us in the case for a lot of reasons, among them being that our legal team is excellent. That's why we're the lawyer for the state. I mean, if you just look at the track record of this administration, the work that we've done, I think, is just outstanding. I think ultimately they realized that, and that's how we became part of the team. But again, that was in September, long after the governor first you know, had the idea to bring a case in the first place.
Do you have an idea, an estimate of how much money could be recovered?
I don't. I really don't. You know, we're a long way from damages. We have to prove liability first, and you know, that's the first, as you've already very appropriately asked. I mean, the jury's going to have to sort out, you know, who's responsible for how we got to this place. And at that point, then a value is put on what the damages are, and then the damages are apportioned, you know, between the liable parties. And to the extent the state shares some culpability for that, then of course that plays into it as well. It's a complicated set of circumstances that we're a long ways away from. And so right now, we're just focused on briefing out the issues that we have to brief by January. And then to the extent we need to do discovery at this point, we're doing it.
Do you have a rough timeline beyond that January hearing of how things will go?
Oh, I think it's a matter of years. Any civil litigation, I mean, takes years. I mean, the climate change lawsuit that was brought by this office started 6 months before I took office, and it won't be over when I leave in 2 years. Civil litigation takes a long time, longer than it should. but that's the nature of the game once you get into court. And so I think when I step out of office in January of 2027, I strongly believe that this case will still be going at that point.
Thank you so much.